we switch to real estate, tokenization real estate. So the next two talks are dedicated to tokenization and real estate, and you're going to absolutely love this panel. And I greatly appreciate the efforts of Gabriel Sadoun, who's the head of business development at a company called DigiShares. DigiShares has also carved its name in the tokenization space. If I have some time, I'll talk about a report called the State of the Tokenization Economy for 2023, and they were among the 10 companies that were featured there. He's done something really cool where he put together this panel, which was a great help, and he's going to introduce the panelists today. So with that, I would like to bring up Gabriel Sadoun to do this panel on tokenization and real estate. Over to you, Gabriel.
Thank you so much, Tanvir, and thank you for organizing this great event. So yeah, my name is Gabriel Sadoun. I work with DigiShares. We're a real-world asset tokenization platform based in Denmark with offices in the US as well. I'm based in Miami. And I'll be the moderator and also panel participant for this next talk. And I'm really happy to be joined by two great panelists. We have Ryan Zega from tZERO, which is one of the leading secondary trading venues in the space. And we have Gary Rommel of Allomer Law, who's a very knowledgeable lawyer in this space as well. So with that, I'll let both of you briefly introduce yourselves, and then we can get going.
Yeah, awesome. And thank you for the introduction and having me on the panel discussion. My name is Ryan Zega. I'm a senior director at tZERO. Joined the firm about 3 years ago to initially spearhead our real estate and fund initiatives. And at this point, work with a wide variety of private companies, partnerships, and other issuers that are looking to either raise capital, tokenize, and or trade on tZERO. Prior to joining tZERO, I had a very traditional acquisitions, asset management, and debt origination career at Paramount Group, Normandy Real Estate Partners, and PGIM Real Estate. But love to hand the discussion over to the next panelist.
Yeah, Gary, if you want to briefly introduce yourself.
Yeah, hello, I'm Gary Rommel. My background, I was in the Air Force for a lot of years. I used to run the airborne computer networks aboard AWACS aircraft, the big radar plane. I went to law school at Loyola in Los Angeles. I started specializing in IP at a large firm, and then I shifted several years ago to focusing just on digital assets and sort of all things blockchain and securities. And I'm based in Monterey, California. I'm licensed to practice law in California and Washington. I'm actually traveling at the moment, and I'm in Utah, where I'll talk in a minute about some good legislation coming out here.
That's great. Thank you, Gary. And just for my background briefly, before joining the DigiShares a bit more than 2 years ago, I used to work for a small investment bank in New York City on capital raises within the alternative investment fund manager space. Okay, so let's get started. So in previous panels, the tokenization has already been defined, and I'm sure you all are quite familiar with the basic definition, so we won't go into that again. But I want to look at it from a practical level and see and try to understand how what the real estate tokenization process looks like. So if someone were to tokenize, to want to tokenize a real estate asset, what would that look like? And I often speak of three main pillars: the legal side, the tech side, and the secondary trading side. So I guess a great way to start would be if Gary, you could tell us what the legal process looks like to tokenize a real estate asset.
Absolutely, absolutely. So as we all know, there's three basic asset types that go on a balance sheet. There's a financial asset, there's a tangible asset, and there's an intangible asset. Financial asset, cryptocurrency, stock, bond. Tangible asset, real property. Intangible asset, intellectual property. Well, what are we doing when we actually tokenize real estate? There's a narrow use case where we can turn the title into a token. right? And then the title settlement is actually the token transfer. That's extremely narrow. Somebody like Proppy is already doing that in Palo Alto, where you're selling a whole residential property as a token, but that's really not what we're talking about here. We're talking about generally people want to use it as a REIT, in which case they're not going to want to operate as sort of a bare DAO entity, or else they'll just be schwacked as a partnership, and there'll be liability all the way around. So we've got to wrap it in some sort of an entity. And that brings us to our typical US entity choices to discuss first, and then sort of the newest ones. You've got generally, partnerships, which we've ruled out, limited liability companies, or corporations. There's also, as of, I believe, Vermont was the first one to do it, a BBLLC in about 2018. The next one was Wyoming. Wyoming did a DAO LLC in 2021. After that, Tennessee modeled after Wyoming's law. And then Wyoming in 22 went back, and their legislative session made some amendments, which had some problems with my filing. There used to be some management issues. You can manage an LLC as a manager, and then there's members. And they intended for it to be member managed in like the state of Wyoming. So you've got those basic entities, and it's really a matter of choosing, do I need an actual DAO entity, or do I need a corporation or an LLC that a state allows the cap table to be managed on a distributed ledger? There are other states like Delaware, New Jersey, Texas, Nevada, even Iowa, California, which legislation is going to expire in a few more years. They just extended it, that allows a corporate record to be kept on a distributed ledger. So it's not necessarily a DAO entity where it's envisioned all members manage it equally, that you can have that just a regular Delaware corporation, a regular Delaware LLC, a regular California corporation, and you're simply tracking your membership or your stock on a distributed ledger. Gabriel, is that? And I was going to say there's basically 5 types of securities and securities forms. You've got certificated securities, which most people have gotten away from, right? We're all doing book entry shares. And then, so there's certificated, there's book entry, there's dematerialized non-certificated shares, there's digitally enhanced non-certificated securities, and there's digital asset securities. So when we think about, we've tokenized a corporate stock, right? That stock, if that token directly represents that stock, that's a digital asset security. And transferring that token is transferring the stock. Now, most people aren't doing that yet. That's where we would like to get to here in the United States. That's where our legislation should be going. I think that's going to be a better system. But right now, the way most of us are doing it is as a digitally enhanced non-certificated security. And by digitally enhanced, it simply means we're keeping a carbon copy of that capitalization table on a blockchain for the participants to access that ledger. So it's not just our book entry as a lawyer or as a corporate counsel. It's a book entry that everybody has a chance to participate in and hold a piece of. So there's more transparency and a little more security.
Very clear. Thank you. Thank you, Gary. And so once you have the entity set up, and if you're raising capital, a legal game plan set up, you're going to need a tech platform for the initial intake of investors for the primary raise. So I'll just talk briefly about that side of things. So the only thing you need on the tech side to begin with is a website. And on the top right, generally, you'll have a button that says, sign up or invest now. And that's where people will click to be pushed into the back-end tokenization platform that you'll select. And some people do it white label, some others not. At DigiShares, we're white label, for example. But that platform should enable you to create the smart contract and to investors. And so you'll have to choose potentially various integrations like the KYC provider to make sure that you're compliant and that every investor is checked against the anti-money laundering list, for example. You'll have a e-signature integration, payments, whether it's crypto or fiat. Some people think that because an asset is tokenized, you can only pay with crypto. That's not necessarily the case. You can have fiat and then the tokens are delivered. And custody, same thing. You know, you don't necessarily have to have a self-custodial wallet like MetaMask, although that could be seen as more elegant in terms of the tech. You could have a custodial solution as well with a third party that's registered as a trust and that's regulated as such. So investors don't necessarily have to bring their own wallet. So these are all considerations that you're going to figure out with the tokenization platform provider that you're going to choose. And depending on the type of offering, if you're raising capital, if you're doing a Reg A, for example, raising from US retail investors, you're going to need a transfer agent. So that's something to check for as well, that the provider has that license, the transfer agent license. But in any case, you know, there'll always be a cap table management tool and a way to send distributions and organize votes and communicate and things like that. And so once you have all of this, people can go to your website, click sign up or invest, go through the flows, and they can become a shareholder in the project. And that's when trading can start. And so I'll hand it over to Ryan for more on that.
Yeah, definitely. No, thank you for that comprehensive overview. And then, yeah, basically at tZERO, we deal with two different circumstances. One is similar to what Gabriel discussed, an issuer that's going out to raise capital. And, you know, as Gary noted, there's a variety of ways to raise capital, Reg D, Reg A, Reg CF, kind of choosing that pathway forward. And then they might identify tZERO as their intended secondary trading platform. The other circumstance is an issuer that's already raised capital. So they may have raised capital for a private company, an individual private placement, a fund, or, you know, some other structure. And they're basically coming to, you know, tZERO and or DigiShares to take that existing structure and allow it to trade on our platform. So we'll conduct due diligence ahead of trading, basically business, reputational, and legal due diligence, get an understanding of the asset, you know, what's trading, depth of cap table, et cetera. You know, obviously go through sort of the formal documentation. And then once that asset's eligible for secondary trading, which will partly depend on the type of offering that's been utilized, as well as the applicable seasoning period, we'll then onboard those individual issuers through our retail broker dealer. They'll open accounts, go through their KYC and AML process, be preceded with shares, and then once trading commences, we'll basically flip the switch, and then that trading will commence on a live continuous basis, you know, depending on the kind of asset type, offering type, et cetera. And then that trading venue, right, who will be able to trade that asset will be dependent on the type of asset that's offered, and then whether it's eligible for trading amongst non-US and US investors, whether it's among both US-based and or non-accredited and accredited investors. And basically, we have the ability to set those guardrails within our trading environment. So, you know, other than real estate, we're working with a number of different asset types, private companies, natural resources, sports teams, et cetera. So it's a very diverse pipeline that, you know, we see here. And then we're also working on customized solutions. So trading with cadence, right? Semi-annual, annual, and quarterly trading, or even recapitalization. So, you know, tZERO as a whole is pretty flexible on what we can provide, and it really is on an issuer by issuer basis, depending on how the issuance was done, what offering type is being utilized, the structuring, et cetera. But yeah, just turning it back to you, Gabriel.
Yeah, thank you. And I think you mentioned something very important, which is the lockup periods. You mentioned it briefly. I think it may be useful to just double click on that for a minute. Could you explain a bit more and how it ties into all of this?
Yeah, exactly. No, that's a good question. So depending on the offering type that was done, you know, that partly dictates the secondary trading period. So good example is, a Reg D 506C, for instance, or 506B, can be tradable under certain rules and exemptions. One is Rule 144, which allows for a broader trading environment 1 year post capital raise. We also see Reg Ds that want to trade potentially under 4A7, which allows for trading as early as 90 days. Obviously, these are just kind of like broad brush strokes, and I would, work with your counsel to determine what your applicable trading period would be. But that's some, kind of high level thoughts there. On the Reg A side, we have a number of Reg A issuers that have gone through qualification, that are raising capital, and then looking to trade, as early as almost immediately post capital raise. So yeah, that's something to be mindful of, right? Depending on your offering type. And then, obviously your counsel will be able to provide more fulsome details on what that secondary trading would, be like. And I'm sure Gary has some thoughts on that as well.
Yeah, maybe Gary, if you have some thoughts, and also how it ties into the smart contract itself, that could be interesting.
That's it. Yeah, how it ties into the smart contract itself, especially with these, we like to have holding periods. For the 144 holding period would be 12 months for a non-reporting company or 6 months for a reporting company. You've got 4A7, like Ryan discussed, and then you've got the old, 4A 1.5 rule that was codified by 4A7 with statute. If it's a Reg S, if we're selling a U.S. company to non-U.S. investors, we're kind of under a different rule, 903, 904. And again, that's still sort of a 12-month holding period. What I like to recommend to issuers using platforms like this is to go with the Rule 144, because that mirrors the foreign rule. And we can actually program that into the token. You can use, I believe DigiShares, you're using, like I say, they can use different blockchains. If they use Ethereum, they can use, 1404 standard, and they can program in the holding period for that token representing that security. So it absolutely cannot be transferred until that holding period is up. And then they can implement their KYC or any other accreditation issues if they would like, which they don't have to be accredited after a year in a 144. And that is very helpful, because before this programmatic option, it was just the Wild West with who could transfer what, and it was a bigger concern with SEC about control over those tokens, and that concern has been alleviated by the latest protocols.
Thank you. And so now I want to talk a bit about the benefits of doing this, and tie it into maybe a case study. And I'll hand it back over to Ryan. If you could maybe talk about liquidity and what you guys have done at tZERO.
Yeah, definitely. So, when we think about kind of tokenization and tZERO specifically, issuers tokenize to trade on our platform. So they're taking an existing asset that, typically is very high barrier to entry and illiquid, and then allowing those investors to come onto our platform and then transact in a much more fluid manner amongst hopefully a wider audience. So yeah, a lot of our issuers want to have that benefit to their existing LPs of, hey, let me allow you to trade as I'm creating value in that potential 5, 7, or 10-year hold period, right? Regardless of it being a real estate asset, a fund, or a private company. So yeah, that's kind of one of the things, right, is, providing that wider audience, and then your existing LPs the ability to trade. And then we have a lot of issuers that are out raising capital with secondary trading in mind, so that you can differentiate your product and essentially raise capital with this added benefit of secondary trading versus, your LP being in a very traditional structure where they're illiquid for that time period. But yeah, Gary and Gabriel, I don't know if you want to go into, some of the other, aspects, P2P transfers, et cetera.
Yeah, for sure. And I think, one great consequence of having the liquidity optionality and a platform to efficiently trade is that then more people can participate. So we talked about the lockup periods, but so people should understand that after the lockup period, anybody can then trade. And even retail investors. So that's opening up barriers, or taking down barriers, sorry, and creating opportunities for smaller investors to participate. It's kind of like doing a mini IPO without having to become public, which is really an expensive process. So you can, I think democratization is a great consequence of an advantage of all this. Yeah, I would also mention the atomic swaps. That's an important concept to understand when it comes to payments and settlement. So the atomic swap is a smart contract that two parties can enter into with their wallets, and it'll verify that the terms of the trade are respected. So on the one hand, you'll have it'll verify if you have the number of tokens that is going to be traded. On the other side, if there's the correct amount of USDC stablecoin, let's say, that's meant to purchase the tokens, and then it'll effectuate the swap automatically in a disintermediated way, and so that cuts out potentially a ton of middlemen, such as escrow and potentially custodians, and maybe later on the central securities depositories or the transfer agents and the banks that are acting as middlemen within the SWIFT system and all that. And so, by really lowering the amount of intermediaries, you're lowering costs, making the trading experience more efficient, and enabling these smaller investors to participate. So maybe the primary raises will still be done by larger investors, like in a real estate development, commercial development. Maybe you'll have some large investors providing the seed capital, just like VCs provide seed capital for tech companies. But then in the secondary trading, anybody can come in and trade, and we can potentially move away from a world where the only way to trade real estate easily is via real estate investment trust, which only represents 1% of the total real estate value worldwide. And maybe that 1% can go above 50%, as is the case for listed companies. I think it's 56% of Americans own a piece of a public company. So it's really broadening access to people for real estate. And so I'd like to turn things back to Gary. If you have any further benefits that you'd like to talk to on the compliance, governance, transparency side, and if they're also interest. You mentioned that you were in Utah and there's interesting legislation. And if you'd like to talk about some legislation, that's
thank you, Gabriel. Yeah, the Utah legislation here used to be like Wyoming, the Tennessee law. Those were DAO wrappers. They took an LLC and they tried to wrap a DAO under it. The Utah legislation coming out is sort of a brand new entity that's it's an LLD, a limited liability decentralized autonomous organization. And Utah, they're trying to beat Wyoming as sort of the blockchain capital for this store. There's a lot of fintech activity that happens here. That allows the members, it's like I said, it's not a manager managed item with the Utah LLC. The members will manage it, and they have to have legal counsel, which of course I like, to manage any contracts in the real world, because they imagine, people have to actually operate at the periphery. And the Utah legislation, it's not set to come into effect until January of next year. So that's when we'll be taking a hard look at it for other people. The thing to note about the Utah legislation is Wyoming and Tennessee just suggest that we use a non-permissioned public blockchain, right? Or a permissionless blockchain. The Utah legislation requires a permissionless blockchain. So that's a little bit of a game changer. They also recognize that there's maybe some partly autonomous management that can happen. And there's some dissolution issues that don't occur with Wyoming. If it goes dormant in Wyoming for a year, it can just dissolve itself. And it's just a different beast. So I'm very excited to see the Utah legislation come up, and we'll see how that affects other blockchains, like Ethereum. There was some recently, just on the technical side, people figured out how to use Verkle trees to run stateless nodes, Ethereum nodes, on a cell phone. So that's sort of a latest innovation. So we might be able to see some different, instead of having a wallet, somebody might be able to actually run a stateless node and see the state of the ledger directly from their phone while they're running their own validator. And that could be an innovation that really helps this become more mainstream. Behind Utah's legislation is New Hampshire, who is also, they're kind of mirroring it after Utah. So that'll be another one to watch, is New Hampshire.
Thank you, Gary.
I want to do a time check. The panel has been great, and I wish I'd given you guys more time. If we can start wrapping up, that'll be great, so that I can bring up the next speaker. And can't wait to see you do a masterclass in California.
Thank you, Tanvir. Appreciate it.
Thanks, Tanvir. I just going to wrap up as well, and say thank you to the panelists, and to you, Tanvir, and to everybody who listened. And yeah, hand it back over to you, Tanvir.
So Ryan, Gabriel, Gary, thank you so much. Gary.